Okay, I guess we get started because we are at least 2 minutes on top of the hour. So, hi everyone, welcome. My name is Amrita Chaudhary, and I welcome you to this online discussion on behalf of CCUI. For people who do not know, CCUI is a trust engaged in capacity building, advocacy, and research in India mostly, and we work on internet and digital policies. And we represent the interests of different internet stakeholders in India, which includes connected and unconnected users. And for over 1.5 decades, we've been actually working on capacity building initiatives, webinars, conferences, events, and conducting research on issues related to internet and governance and digital policies. So as you are aware, most of you, that there is a draft of the Digital Competition Bill, which the Ministry of Corporate Affairs has released for public comments now till 15th of April. So this discussion is being facilitated to understand more on the various aspects of the bill, because it's a pretty comprehensive, long one, which proposes to regulate the digital markets. There are various criteria and rationale being shared, such as, creating a selective list of core digital services, new terminologies used like systemically significant digital enterprises, etc. There have been obligations, capacities, and again, new powers invested on the CCUI. There are penalties, exemptions, etc. So we want to further deliberate on this and to provoke thoughts on actually what should a competition governance framework in India look like. And this, as you know, is live streamed and recorded. And the outcome of this discussion, we would be preparing some key takeaways and suggestions. If we have time, we will share it in advance before the submissions. But if the deadlines are not changed, we would submit it with our submission and circulate it to all the stakeholders. So we have, as many of you have seen, we have a very distinguished panel of speakers with us today who would be talking on the various aspects of this bill. And we would want to keep it as interactive as possible. So for the participants, in case you have any queries or questions, you could put it into the chat. If it's a question, just prefix it with question. If it's a comment, you could prefix it with comment. During the open discussion, you can raise your hand and we will try to take the questions at that point of time. Else, some questions the experts may also respond in the chat. And when you are speaking, please do mention your names and affiliations, if any. While we encourage you to participate as much as possible, but do remember that be respectful and courteous to each other. Your opinions may differ, but we don't want to demean each other. We don't advocate using any kind of abusive language or personal attacks here. And if you're not speaking, please keep your mic muted. So firstly, we will have Saksham Malik from the dialogue, who would be giving us a very high-level overview of this draft bill. We can't go into in-depth part because it'll take a very long time. Then we have the moderated panel discussion, wherein we have our esteemed speakers. We have Samir Nigam, who is from PhonePe. He's the founder and CEO. Anupam Sanghi from Anupam Sanghi Associates. Vivan Sharan from Koan Advisory. Meghna Bal from Esya Centre. And let me tell you, there may be some noise because there is some construction going on nearby. So my apologies in advance. We have Navneet Sharna from CIRC Institute for Regulation and Competition, which is also called CIRC. And we have Professor Viswanath Pingali from IIMA Ahmedabad. And with this, since we have a tight schedule, we would request everyone to keep to your times. So Saksham, over to you, please do share with us the overview and some comments from your end too.
Thank you, Amrita. First of all, thanks for inviting me and having me here. Good to see more of these initiatives. As I say, in civil society, we need, the more we do of these consultations, the better. And good to see a lot of friends here on the panel. So I will provide a brief overview of what the law is all about. Because as you've given me a very hard task of summarizing it within 10 minutes, but I'll try my best. So I'll just share my screen once. One sec. Yep. You'll have to guide me, Amrita. Is it visible? Is it clear?
Yeah, it's visible. If you want to go into the complete, yeah,
Basically.
that's perfect. Yeah.
Yeah. Yeah. All right. So digital competition law. I think we all understand why we are here in the first place, what the hype is about, what the development has been. However, for the benefit of a few people, I see we have more than 60 people in the room. And while a few of the people, especially the panelists, may have a very good grasp on what is happening and what's the background, for the benefit of those who may not, I will just go back to the basics very briefly. Uh, so starting with why are we here in the first place, right? What's the background of this entire discussion? So as a lot of you might know, we of course have a traditional sector agnostic competition act in place, which has been in place for a long time. However, what was observed over the past few years by the Competition Commission of India and other policymakers, that the laws that we currently have in place and the frameworks that we currently have in place do not adequately address certain competition law harms and competition law concerns in digital markets, right? In various ways. The first example or the first evidence or the first argument that is often made for the introduction of a whole new landscape is that the current frameworks are very slow. Now, the argument that is often made is that digital markets are always going to move much faster than the laws that can address them and the laws that can actually tackle them. And Competition Act especially has not been able to keep up with the pace of digital markets, right? Considering the example of enforcement, so to say. So now a case before the CCI may take a couple of years, so somewhere from between 2 years to 5 years or even longer, right? Because there are multiple stages that the case has to go through, right? There has to be a DG investigation. Before that, there has to be a prima facie order, and then there are interim orders sometimes, and then there's a final order, and even then it can be subjected to appeal in High Court, Supreme Court, and CLAT, right? So it's a long process. Now, tech markets by that time have already gone through a certain cycle where they have either tipped, where the network effects have become so high that the damage that has been done to the market is so irreversible that these laws are not sufficient, right? So that's one argument, that why are we here in the first place? Secondly, ineffective enforcement by the regulator. I mean, linked to the first point that the regulator, of course, has limited capacity, not in terms of the personnel only, but also in terms of the tools it has, right? So a lot of tools it has that have been used by competition regulators in India, and not just India, across the world, are not exactly equipped to tackle digital markets, right? So one example that is often given is that the standard, that golden standard of assessment, that whether conduct X or conduct Y is anti-competitive or not, is the consumer welfare standard, right? Now, the consumer welfare standard essentially is built, I mean, for the lack of a better word, and oversimplify it, is built on prices. Whether a certain conduct leads to, let's say, some sort of increase in prices and harm to consumers subsequently, right? Now, in digital markets, a lot of services are essentially free. So if I say that, okay, this conduct is not anti-competitive because it was free earlier and it's free now, it doesn't really make sense, right? So the policymakers have felt that we need newer standards. So newer standards have developed in the US, in EU, in various countries, and it has led us to a point today in India as well as other countries that we need new frameworks, right? And then there's a lapse in current laws. Now, the current laws that we have in place, what is often observed is that digital markets, again, are not going to be regulated efficiently with the Competition Act that we have in place, so to say, right? If I give you an example in merger control, right? Ironically, merger control is not a part of the new law, but to give you an example of how broader ex-ante frameworks look at these issues. If you look at merger control, uh, in India, the Competition Act is based on two thresholds: assets and turnover. What that essentially means, if there's a transaction in the market, right, and the transacting parties have assets or turnovers above a certain number, right, then that transaction has to take the approval of the Competition Commission of India, so that the CCI can see whether this act or this conduct, sorry, or this transaction can have some concentration risk, can have some anti-competitive effects in the market, right? Now, the problem here that has been realized is that in tech markets, a lot of these organizations are often asset and turnover light, right? They don't need a whole lot of infrastructure. However, that does not mean that there is no scope for anti-competitive harms. The amount of data that companies often have and the intention with which they often acquire smaller companies may still be enough reason for them to be assessed by the CCI before that transaction can take place, right? So there have been a couple of reasons. These are three of the major reasons, but of course there are multiple reasons why we have come to a point that we have felt the need for a digital competition act in India, right? Coming to the chronology, won't spend too much time on this one, but just to give everyone an overview, that the story did not start in India with a finance committee report in 2022. The story in December 2022. The story started, in fact, with the Commerce Committee's report when it comes to policy making. I'm talking about, not enforcement. The Commerce Committee in June 2022 came out with a report which recommended an updated framework for digital markets. Right. Fast forward a few months, that is when we got the Finance Committee report. Now, for those who do not know, the Finance Committee or the Standing Committee on Finance, or in fact any standing committee, more often have members of parliament from both houses of the parliament, right? So there will be some members from the Lok Sabha, some members from the Rajya Sabha. They will sit down, they will actually get some people to depose before them, they will collect inputs, they will do their own research, and then they will come out with a report. That happened in December 2022, the major report that has for long formed the basis of digital competition in India. That report came out in December 2022. They recommended a whole lot of measures. 10 to 11 practices they recommended should be done, 10 to 11 suggestions. Prohibitions on, let's say, time and bundling, prohibitions on some sort of data usage practices, etc., etc. Based on that committee report, the Ministry of Corporate Affairs set up a new committee called the CDCL, the Committee on Digital Competition Law, the buzzword that is on everyone's lips nowadays. That committee was formed in February last year. They took more or less, let's say, a year now to come out with this report, right? And that report has come out just in March this year. In the meantime, we've also seen some smaller developments. The DMDU has been set up, a new unit for digital markets in the CCI has been set up, right? But the major development of where we go from here is that we have a deadline now, essentially, because the CDCL has submitted its report and a draft bill. It's a 200 plus page report, and it goes into a lot of detail about why they have recommended certain provisions, and then there's a draft bill attached, right? And that draft bill and the report is the subject of a lot of discussion, including the one we are having today. Moving on to the actual bill, right? The scope of the law, right? Uh, how did when I say the scope of the law, to oversimplify it or to for the benefit of everyone in the room, the scope of the law, I mean, which sectors essentially the law wants to regulate, right? That is included in Schedule 1 of the bill, where they have a whole lot of services that have been mentioned. And please mind that this is a non-exhaustive list, meaning that if tomorrow the central government feels the need that we need to add more sectors to this list, they can do that by its rule making power, right? But the sectors which are already there are online search engines, social networking. The list is in front of you, video sharing platforms, etc., etc. Right now, why these sectors? Right, the report's guidance says that they have chosen sectors which are at the risk of concentration. Now, there can be a lot of debate about either whether that is the correct metric to include a sector in the Schedule 1, or do we need maybe a higher standard of what needs to come in. Some people have argued that, you know what, no, just look at the sectors which have actually observed certain competition harms in the market and choose those sectors. Any sector can be at the risk of monopolization or concentration, especially in tech markets. That is not reason enough to include those in the list. The other side says that, no, you know what, uh, the government needs to have enough agility, right? Yes, there may be more sectors in the future. The government needs to have enough agility. The scope needs to be as broad as possible to ensure that wherever there's a risk, we can regulate. Now, that's the scope, right? I won't go too much into it. We have a new report out today. I will put the link in the chat where we have gone into some parts of the law, including can you as an entity have obligations under the law, right? So to give you a brief overview, if you are someone, let's say an entity X, can you be one of those who have an obligation under this new law or the proposed bill? So the first thing you have to see is that do you provide a core digital services? So the 910 services we saw in the last slide, do you provide any of those, right? If no, you're safe or you're out of the purview unless the government adds your sector to Schedule 1. If it does have, if you do fall in any of those core digital services, you will qualify. However, what you have to keep in mind is that it's not just important that you are not providing an e-commerce platform, for example. So let's say I, as entity X, I do not have an e-commerce platform, but my sister entity, as part of the same group, they have a core digital service. Then again, I can have certain obligations under the new law, because the law has considered certain thresholds or certain criteria on a group level rather than at an enterprise level, right? So you may have obligations. Now, just one sec, I can see the screen. Yes. Now, This is how you can be designated as an SSDE, right? A significant digital enterprise, right? However, there's another concept called an associate digital enterprise, right? So now tomorrow you say that I am not providing any of these core digital services, right? However, there are other people or other entities in my group which are providing certain services, right? Now, if that entity, let's say entity Y, is actually providing core digital service, right, and they have already been designated as an SSDE, or they're in the process of being designating an SSDE, the CCI is actively considering. Then, in that case, if you are involved in any way, let's say you're helping them, you're providing them data, you have a similar business operation, if you are involved in that service being given, then also you may be obligated as an ADE, called an Associate Digital Enterprises. So the level of obligations on your entity may be smaller or lower or lesser, but you may have the obligations nonetheless, right? So just the next slide. Okay. Now thresholds. So it's not enough that you are in the core digital services, right? Now I'm coming back to the SSD. You can be an SSD. It's not enough that you or your group entity is in a core digital service. There is another role that is being played at the next level is the thresholds. So there are certain thresholds that are available. I won't go into each of them, but there are those available as you can see on turnover, GMV, global market cap, and end users. So on one level, either of the thresholds you see on the left, you have to satisfy any of them, not all of them, in the last 3 financial years. Plus, to prove that you have a local nexus to India, it has to be satisfied that you have end users or business users above this threshold in India. So for the lack of a better term, if you have a core digital service in India or your group entity has a core digital service in India, plus if you satisfy of any of these quantitative thresholds, you may end up being designated. Then there are qualitative thresholds. I won't go into all of them. You can see it in our report. But even if you don't qualify, even if you don't satisfy these quantitative thresholds that I just showed you, does not mean that you cannot be designated as an SSD. The CCI, if it considers that you have sufficient market power or you have sufficient control over the market, based on all these criteria, all these factors that you see on your screen right now, the CCI may end up designating you an SSD nonetheless, right? I won't go into this, but this is essentially a process. How will you be designated as an SSD or an AD? There are multiple things on the quantitative side, on the qualitative side. On various levels, you will be provided an opportunity to be heard. And throughout that process, the CCI can ask you for information. You will have to give your information, and then they will designate you. I'll paste the link to the report. You can go through it there. To the more important point, right? Now, let's say you've satisfied the core digital service, and now you have also been designated an SSD or an ADE. Now, what kind of obligations can be on you, right? Where we've done a good job or a better job than the EU DMA, at least, is that we have not implemented a one-size-fits-all approach, right? We are not saying that every entity has to do all of this. Instead, we've gone through a model where the act or the bill gives you a list of 6 principles, right? 6 to 7 principles, and it says that the CCI will come up with regulations for different sectors, for different core digital services, the one we saw in the first slide. So let's say a different set of regulations for e-commerce, different set of regulations for cloud, different set of regulations for video platforms, etc., etc. Those obligations, those do's and don'ts will be based on certain principles. And these are those principles: time and bundling, self-preferencing, restricting third-party apps. The CCI will see which of these principles apply, in what form they apply to your business. It will be a participative process. The entities will be on the table, the CCI will be on the table, there will be some sort of consultation, and then regulations will come out. Last slide, because I understand we don't have a lot of time, is on policy overlaps, right? Because one side of the story is that this law is in place, or this law is coming out, right? Sorry. However, what needs to be considered is that are there sufficient laws already, or are there any laws in place or being considered by the government which might overlap, or in fact, dare I say, conflict with the proposed digital competition bill, right? Now, I wouldn't say that the CDCL committee did not have cognizance of this. There's a whole chapter dedicated to overlaps and conflicts. There may be conflicts or overlaps with the Digital India Act that we're considering, with the TPDP Act that is already in place. However, where I feel there has been a bit of a gap is that they acknowledge that there are certain overlaps and conflicts. However, as a researcher or as an academician or as a policy analyst, I do not see what was done about that, right? So let's say they say that The scope of FDI policy is very narrow. They look at neutrality from only an e-commerce point of view. The digital competition will be looked at a broader point of view. Conceded, but what about that limited overlap? What did you do about that e-commerce overlap, right? So the overlaps and conflicts are recognized in the report, but nothing has been done about it, right? So we did an assessment last month on all these overlaps, how it overlaps with different laws, what can be different challenges that this overlap brings about, and what can be the way forward. What sort of inter-regulatory mechanisms you need. Because mind you, the report itself says, the preface of the report itself says that you need an inter-regulatory consultation mechanism between different ministries, etc., to come up with a mechanism which can ensure that there is no overlap or no conflicts, right? But what will that mechanism look like? We do not know after reading the report. So there will be sufficient there will be sufficient discourse needed on that part as well. So if you ask me to summarize the major parts that we need to have discussions on, not necessarily at this panel today, but going forward over the next few months, is the consultation timeline. 15th April, I think we are at what, third already. We had less than a month. In my opinion, if I had to give my opinion, ridiculously low, not enough at all for me, even as even as someone who does this day in, day out to submit my comments, let alone your gig workers or other stakeholders. The scope of core digital services, I mean, certain sectors are there, maybe because there are cases ongoing, maybe because there is a final order, but certain sectors, I do not understand why they are there or what is the risk of concentration. How did you arrive at that? Thresholds, are the numbers high enough or low enough? Do we need to adjust them accordingly? Do we need to look at these numbers at a group level, right? If my other entity has nothing to do with my core digital service, why is its threshold being considered? And lastly, the point would be, of course, on policy overlaps. So that is where I end. I believe I'm 3 to 4 minutes over time. So yeah.
Right. Thanks, Saksham, for that comprehensive overview. I know we tried to, cramp it into very short. But we'll call you in for your inputs. And if you could share the links of your reports also here, it would help the audience.
I'll just do that in 1 minute.
Yeah.
Over to you, Anupam.
Thank you. And now I'll go to the panelists, and I see Meghna first, so I will call her first, and then I'll go to Samir. And my question to all the panelists would be, Saksham raised some points, but from your perspective, and all of you have been looking at it or working on, like Samir is someone who is into the digital space doing business, or for Meghna and others who have been looking at it and researching, etc. What are your main comments on the bill? What works, what does not? For example, it's concerning on the list of CDS. Some of them do not seem to have done much harm in India. But I don't want to put words into your mouth, but Meghna, over to you. What are your concerns? What works, what does not?
Yeah, it's interesting that you mentioned that some of the CDS there's little to no evidence of competitive harm regarding some of the CDS, but really, since none of the matters involving any of these CDS have reached finality, there is no conclusive evidence, only allegations. But going, or I guess moving back a little bit, let's consider the context in which the DMA, which is the European equivalent of this law, came about. So there's two points there. The first point is that the DMA had to be introduced, whether the European Commission will ever admit it or not, because the GDPR created a significant market failure where it made collection of data very expensive and cumbersome and difficult for data startups. And at the same time, because larger companies were able to move to jurisdictions that were friendlier in terms of GDPR enforcement, like Ireland, they were able to do so, and therefore they saw an entrenchment of their position as a function of GDPR. So the DMA has come in part because of the market failure, or has come to rectify the market failure caused by the GDPR. We don't have the same context here. The other context, of course, is that the Europeans are kind of betting on short-term pain for what they are hoping is long-term gain. Though, as we see the proposals in relation to the DMA that are coming out in terms of compliance, and we're already seeing that investigations are now being launched into some of the companies that essentially that the jury is uncertain. So basically what I mean by short-term pain for long-term gain is that there would be some disruption in these digital markets, but basically they are hoping to supplant what they perceive as a predominantly American tech ecosystem with some of their own players. Again, Indian context is different. There are multiple markets where Indian companies are leaders. So again, the justification or the political economy around this is very limited. And to just say that you are going to bring in a law that essentially disrupts the way a big chunk of your digital market operates, because it's not only dominant entities, the threshold of 10 million will not only catch, let's say, the largest entity in a particular market, but will catch smaller ones as well, mid-sized ones as well. Just as a function of them providing these core digital services, and it's not only core digital services that are regulated, right? Through the kind of vehicle of core digital services, we see that this act also catches any other service that you provide. And invariably, in a lot of the provisions, it's not only core digital services that are mentioned in terms of the restrictions, but other services as well. And I'll get to that in a bit. So in terms of the impact, we did a study on the potential impact of two of the provisions in this law, one related to data usage restrictions, specifically Section 12.2, which says that an SSD cannot intermix or cross-use the personal data of business users and end users without their consent. And it also cannot permit the usage of such data by any third party, again, without their consent. There are some doctrinal issues there, but I'll get to that in a bit. Essentially what this does is there's a similar provision in under the DMA, which is Article 5.2. And essentially the goal of that provision is to reduce the targeting capabilities for advertisement services on these platforms. Now, the CDCL has not expressly stated this goal, but the DMA does in recital 37. So we can presume that the objective is the same, given that the framing is the same. Now, what we did was we interviewed 300 MSMEs in India from all over the country, and we found that there was overwhelmingly positive support for their reliance on targeted advertising for things like revenue generation. So 85% said that it was positive for revenue generation, for customer acquisition, for time saving, for cost reduction. So there's a lot of efficiencies that are gained by MSMEs that are usually unable to access and compete in markets because of their small size and their resource constraints because of targeted advertising. And we asked them that if a law came in that reduced the efficacy of targeted advertising, how would that impact you? And 61% of them indicated that it would negatively impact them. So the question then becomes that comes to the fore is, why are we even considering a law which leaves a majority of our business users worse off? And that brings us to the framing of the law, which is also problematic, which is that it looks at digital markets in the narrow frame of businesses and SSDs competing with one another and refuses to kind of acknowledge the complementarities between these entities. Then another aspect that we looked at was single sign-on. So if any of you have used any e-commerce site, essentially you know that and you would have seen that it'll ask you to sign in through your Google account or through your Facebook account, Amazon account, etc., etc. So what that does is it saves the business that is using that service the hassle of maintaining multiple accounts, and similarly it saves you the same hassle. And we found that close to 80% of the MSMEs that we surveyed relied on this service. And very often these services are offered as bundles. But if you look at the restriction on tying and bundling, I understand that it is going to be qualified by regulation by the CCI. But if you look at the restriction on tying and bundling within this law, it's basically a blanket ban on it. So essentially what it would do is it would unbundle all these services that are offered to an MSME. So say an MSME is taking a cloud service with an analytics service and this single sign-on service. All of them would be unbundled, and that would have the effect of raising the price of this service, which would then make it inaccessible. And again, 61% of services indicated that they would be negatively impacted by this. And finally, I'm going to come to the last aspect that we investigated, which is how the inclusiveness of the consultation. So the consultation process was extremely opaque. Several civil society organizations, in fact, wrote a letter to that effect. And we found that 76% of 74%, sorry, of MSMEs that we surveyed had not participated, and with 22% having not even heard of this process. So all these things come into question, particularly given the strong disruptive potential of this law. Then we can go into, I mean, Saksham touched upon this a little bit, but the contradictions with other laws, and I can kind of drill down on the data usage restrictions. One, they seem to create a privacy right in the name of business users, which seems to me both contrary to constitutional principles, as well as what is there in the DPDPA, which is the Digital Personal Data Protection Act, where you only have only individuals are regarded as data principals, not businesses. Next, it also seems to go against basic principles of intellectual property, both under the Copyright Act as well as under our obligations under TRIPS, where it creates a property right in the name of business users. But for a property right to accrue for data to you under both the Copyright Act and under TRIPS, you should have shown there should be a modicum of creativity. So I don't know how they've created this right. So I don't know how they've created this right, or the justifiability of this kind of provision in terms of the property right is questionable. And I'll leave it there and I'll
Thanks.
Yeah.
Thanks, Meghna. So, Samir, if you are coming from the business side, and thank you for being here. For us to get a business speaker is always very tough. We reach out to everyone, but most people are reluctant to speak, and it affects end users, it affects everyone, but it affects you first, as in the community there. So, how are you looking at the bill, and how do you look at it?
First of all, thanks for having me here. I try and participate when I'm invited. I think it's assumed that the business community won't speak up, but I think there's a flurry of recent laws and drafts and bills, and I think we're playing catch. I'll be honest, barely made sense of the Digital Privacy Act and catching up late with this one. Let me start at the top. I think we were treading in very dangerous waters on three specific fronts. I think the reference to the sort of romanticized notion that we need to sort of beat GDPR and do a +1 on that, I think has already been mentioned. I see quite a few people who are listening in, and I'd be very curious if any of them, without picking up a search engine, can name 5 internet companies out of the entire EU plus UK in the last 25 years. There's a reason that they don't have a thriving internet economy. It's because they basically lean on largely large tech companies or services coming out of the US. For all core internet services, India is very different. I think we are one case in point. We compete in a space where nobody gave us a chance to compete against WhatsApp Pay and Google Pay and Amazon Pay, and we fiercely compete with, and have stood our ground. Sector after sector, if there's an Amazon, there's a Flipkart and a Meesho. If there's an Uber, there's an Ola. So first of all, I don't think we have Europe's problem. Let's solve our own problems, right? I get very worried when we start acting like Europe. Second, I think Meghna just mentioned, if I'm not mistaken, this idea that businesses need to be treated like private entities. Somehow there's a lot of that flavor in this draft about business rights to privacy, business data not getting shared and pooled. It's a very, very slippery slope. Not because I think business or partner data should be used freely, but a lot of that data is used to actually bundle services right back to them. And I'll give you a very simple example. There's a lot of talk about how MSME lending is actually growing really rapidly, or MSME insurance or financial services to small businesses. And 99% of that is driven by internet companies who work with these sellers or small merchants or small shops on some other so-called CDS, but use that data footprint to work with financial institutions to upsell or cross-sell financial service products to them. Now, you can't go and take permission from a juice center where you offer, say, payment services in our case, or a small seller at a Myntra. You can't go and take permission for sharing their data footprint or even aggregates thereof for each individual potential lender. India has 20,000 odd NBFCs. You put those scores out, there's a very, very different set of frameworks that drive B2B partnerships versus consumers. So the B2B part, actually, this is the first sort of bill I've seen that talks about how you have to work with businesses, and that's a little worrisome. But I'd say above all of that, I think there is an unimaginable amount of power being given to CCI to interpret what is systemically significant, because there's an out clause everywhere. Let's just look at the two limbs. There's 4 parts on the financial, and I think 2 or 3 parts on the sort of user base. Let's start with the users. I think it refers to anyone who has over 1 crore users or 10,000 businesses. If I look at 10,000 businesses in India, apps like Dukaan and Khata would have triggered this clause 3 years ago. Apps like Tally are definitely way past it. Now, they may not be in your conventional thinking of internet companies, but they're all working off the internet. These are connected SaaS solutions today. Freshtest would be over 10,000. Are they all SSTs as far as that limb is concerned? Then let's look at the 4 criteria on top. They've defined an enterprise very, very loosely. I'm actually surprised this is coming from the MCA because they're normally much tighter. Is the enterprise the entity operating in India, or is beneficial ownership entity abroad or a holdco abroad? And why is it important? On the one hand, translating everything into rupees, the global market cap defined is 6.2 lakh crores. The global turnover is 2.5 lakh crores. But if you are in India, the turnover is 4,000 crores. So either we are submitting that, okay, if you are large abroad, you are more likely to cause harm. And this goes entirely into the ex-ante flavor. Otherwise, there's no argument for this. You can't have 4,000 and 2.5 lakh crores. 4,000 crores and 2.5 lakh crores, significantly different. So either what they meant to say is your global turnover for the parent entity, not the India business, is so high that you're likely to cause harm. Or they're talking about an Indian business's global turnover. I have not seen any internet company out of India where your domestic turnover is less than 4,000 crores, but your global turnover is somehow 2.5 lakh crores. I don't know of such company at all. There is none. Right? I know a lot in the opposite order. I know a lot of global companies that have a presence in India. Now, if you're saying your global size could be huge abroad, but a very small presence in India will tip you over. I'll give you examples of that. Let's say there's a payment company that's very popular in the US called Stripe. They have an office with maybe 20 people in India. I don't know, maybe 50. Their threshold is nowhere near 4,000 crores. But their market cap abroad is well over the market cap. The global turnover is well over the global turnover threshold. Are we suddenly saying that the minute you enter the market, you're an SSED? Where's the sense to that? At entry, you've already triggered a limb because you incorporated a subsidiary. You have to look at the market in the Indian market context only, the market turnover, the market cap, whatever you want to have. You have to put it in the Indian context. The minute you start adding the global context, all hell breaks loose. When you take these two in conjunction and you start talking about numbers like 1 crore users, it defies logic. 1 crore users make 10 million users might be the population of one of the EU countries. 10 million is how many students wait for a visa every year in India. 10 million users is one good launch over 7 days. It's nothing. We are a country of 1.4 billion people. We need to put our thresholds in context of that. 1 crore is less than 1%. So less than 1% population reach does not make you a systemically important entity. So I think my worry is that in these definitions and phrases like online intermediation service, which the commission might actually decide what fits into that 9th bucket of classification in Schedule 1, right? Or they may decide whether other threshold should be applied. It's so open-ended. It leaves everybody in the startup ecosystem running scared. Because the minute you leave that kind of interpretive power with a body like CCI, you're basically creating a chilling effect in the ecosystem. The number of people you need to keep happy now. I'm sorry, there's no better way to put it. And I'm an Indian entrepreneur fighting a whole bunch of the guys that they're intending to pass this law to sort of solve for. The number of people you will have to just keep happy is insane. You just don't know when somebody gets upset and says, on this limb, I think you're significant. Let me open an investigation. Those things we need to get better about. Europe did this with GDPR, they did this with their privacy norms. You go into Europe and open an app, you sign 47 consents, ping, 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 like you're playing darts before you actually know what the app does. We don't want to become that market. We are celebrating one of the most vibrant and fiercely competitive startup ecosystems in the world today. And in fact, what we should be doing is giving the CCI more powers to establish properly whether someone's actually behaving monopolistically and go after them. I think in the first slide, Saksham used, I think that there was 3 sort of reasons why this bill was brought in. They're actually all 3 the same, really, which is today the CCI has not been given enough teeth. This is playing out case after case and is playing out against a very few set of actors. The problem is not, for example, whether Google charges 30% or charges 80%. I've launched a competing service. The problem is that they're able to do it because nobody else could play the game. We need to make sure that people can play the game. But you can't tell people before you start playing the games, I'm telling you I might change the rules midways for a number of reasons on you. That's a really bad sign for the startup ecosystem. And I would implore on the powers that be, this needs to be a 6-month consultation at the bare minimum. And it must almost be sort of obligatory to get 1,000 inputs from companies of various sizes. Because the number of stakeholders getting notified here just in that first schedule, I mean, there's 200 companies just in the first schedule. We have to hear each one of them out. And I know I'm going over, but I'll leave you with 3 examples or questions for this group to consider. Again, I think in their mind, they're referring to a lot of multinational big tech companies the way the US refers to them. Have they considered, when they talk about tying and bundling, Tata Neu becomes illegal the day it launched because it offers a loyalty service across a bunch of subsidiary and JV partnerships. On day 0, like the day they launch. Have they considered that SBI YONO would be considered as behaving in an unethical manner, whatever, illegal manner, whatever they call it, because the bank owns YONO and is also cross-selling SBI cards, which is a separate listed company. And which one triggers the penalty? Do they both do it separately? That's number 2. So one is a PSU, the other one's a private company. The third's DigiYatra. It just updated 2 days ago. I opened the app. They're now actually talking about connecting you to the lounges and to the stores in the airport and what have you. It's mandatory on me to use it if I really want to clear any of the first 7 gates at most airports in the country today. I don't know who owns it. I have no clarity on my data rights. But they're cross-selling and upselling. So is CCI going to go after DigiYatra? Is CCI going to go after NPCI, which is cross-selling RuPay, but not Visa and MasterCard? Are they going to go after PhonePe, which is trying to actually promote more use cases and bill payments? Where does it end? Like this whole idea of saying that tying and bundling somehow has become evil. You walk into a retail grocery store, the guy is also selling a fresh produce counter on one side, there's a rack of atta and chawal on the other, and on the third one, he's selling you FMCG goods. What are we trying to do here? That is not the problem. The problem is barriers to entry. The problem is not about what people are successfully doing on the other side. Sorry, bit of a impassioned thing
No,
there,
but it
but
was very valid, Samir. And this is something which has been concerning to us also, is that, the entire framing of the committee of coming up with a report in 3 months was, I think, obviously they stretched it, was quite ambitious, over ambitious, I would say, because this is this needs deliberation. As in, if we are following the EU, they deliberated for more than 2 years. Even if we are aping EU, which we do not want to, but trying to do it in a year's time, and trying to get reactions from stakeholders. Most of us were never even consulted. Businesses, as in different businesses, or even technical community was not, brought into the discussion, because that is essential, as in it affects everyone. So I think we definitely think it needs more nuanced discussion, at least now that there is a draft. We can only request. That's the limitation we have. But I think now I will bring in Viswanath Pingali, Professor Viswanath Pingali, and then perhaps Anupam, who can look at the legal side, and then Vivan. And then Saksham, if you have to add anything. So Vishi, over to you.
Okay, thanks, Amrita. I was listening to what Samir has to say, and I wish he were the co-author of the paper that I'm writing actually right now, because this is exactly what we're also saying on multiple levels. Meghna alluded to one of the studies that she did. Let me allude to another study that we did, where we spoke close to 1,500 startups in India, and close to around 30-35 of them in-depth one-on-one interviews that we did, very, very detailed. A few things that come out to me, which are very interesting. Small businesses use these platforms as a way to kind of expand globally. And more importantly, and this is one thing which I found very interesting, being fed on the diet of Bollywood movies, I always assumed that exporting would mean that you have a bunch of these oldies sitting in a room with all the gold rings on their fingers and thinking out how to export stuff abroad. That doesn't seem to be the case today. You have small businesses as small as 50 lakhs a year actually doing business in the US, and they would attribute it directly to the presence of digital platforms. So therefore, when you're talking about restrictions, on some of the things that these big tech do, what is it that we are exactly talking about? Whom are we protecting? Of course, the regulation can and should probably come in some other areas, and we can talk about it at a later stage. Some of the survey participants have told them how they would benefit a lot from training programs from the platforms and all. Maybe there's something to be thought about in that side, both by the platforms and by the regulatory authorities. But as far as I see it, I think there's a very difficult process as far as this law is concerned. So I'll also argue what Samir has said about bundling services. I've said this in several fora that I've been a part of. What platforms bring to India versus what platforms bring in an advanced economy. I mean, maybe economically advanced economy. Maybe I should rephrase that very clearly. In the US or Europe, I look at platform as an entity that reduces transaction costs, which connects the sellers and the buyers. In the Indian context, I think it's just not only transaction costs. Of course, it reduces transaction costs, but more importantly, it creates an element of trust. Now, if you have multiple, fractions of multiple segments of a value chain, I'm afraid accountability has to be very clear as to if something were to go wrong, which part of the value chain something has happened. So therefore, the level of surveys that a platform brings to the Indian context is very, very, very different from the context somewhere else. So I think we need to be very, very clear about that. I mean, in 2021, I believe Danny Sokol and I wrote an article in Forbes India where we argued what is it that India and Taiwan have in common. I mean, of course, we both hate a common enemy, and I don't want to talk about it. But more than that, I think we are number 1 and number 2, respectively, in terms of the number of apps per capita downloaded. So therefore, if you're giving me something for default in the Indian context, I'm really not sure that the Indian consumers really are sticking to it. There is a lot of word of mouth that goes on saying that other app is better and everyone's downloading. So these are some of the ground realities in India which are Amrita, in my opinion, very different from what you have in the European segment. So therefore, I think taking what works in US and Europe and trying to impute it on the Indian conditions, I'm afraid this is where the problem is. For the small businesses, the role of a platform is not just transaction cost. For a small business, the role of the platform is to set up trust. Now, if there's a regulation that breaks that kind of puts a dent on the trust part of the business, then I think the platforms will actually become a little bit of they will not be able to deliver what they intend to deliver in every sense of the word, and that's where the issue lies up. If I were to order a laptop and a bunch of trash comes to me, and this is a newspaper reported example, for instance, I'm not making up. It happened in my very campus. I will pick up and call one of my old students in one of these major retailers, and I would tell them, "Hey, listen, it happened to me." And I'm pretty sure it will be corrected in a matter of seconds. If it were coming from some other place, I don't know what to do. Would I run to the court of law? I'll leave it to everybody's guess. So therefore, this is the breakdown that I'm afraid of in every sense of the word. Now, here is where the final point that I want to comment on, unless there are further questions that we could come to, is what is this idea of sorry, I think I lost my chain of thought. I'll stop here, but I'm happy to come back to it again.
Right. Thank you, Vishy. Anupam, you have been consulting on competition issues for a long time with your clients, etc. From the legal perspective, how are you looking at this?
Sure. Thanks, Amrita, for having me over and this very timely initiative for this discussion to be held today. Very quickly, I'll just say that the report about the report, it's very comprehensive and a great material for further research. In fact, I wish this was more of a market study of the Indian and the foreign platforms that are operating in the Indian market and how they impact the Indian market and how CCI is facing certain obstacles or information gaps in the investigations, and what are the guardrails that they suggest for scaling Indian companies. We have just about 110 unicorns, which pales in comparison to the size of US and China, the kind of unicorns they have. So while we were still building this up, our digital ecosystem, and CCI has done a good job in terms of studying the market. I'm surprised they didn't even mention the e-commerce study which came out in 2020 in this report, and the other initiatives that they've taken. As Samir said, that one is still trying to catch up with all the flurry of laws that have come in, including the Competition Amendment Act, and after the very timely CLRC, the Competition Law Review Report that came after a decade of CCI. So it was doing well. Now suddenly to come up with propose ex ante laws is something that is not falling in place with the way our markets are moving and the way CCI was moving till now, because they hadn't gone that aggressive. So although I don't have per se a problem with ex ante laws, because it has worked very well in telecom and electricity sector. Why? Because essentially we were opening up these sectors to the private players when the incumbents were the public sector undertakings. So it worked very well in when MTNL, BSNL, and these incumbents were dominating, and the private sector got a level playing field. The broadcasters were told to give access to multi-system operators and local cable operators. So it was to give access and to bring in fairness and transparency. So these ex ante laws per se are not bad in network industries, but to regulate all the sectors across the board and to have the same rules for everybody means to disregard or not to acknowledge the fact that that every digital platform or every sector it has different business models. They have differentiated products and services. So, we are disregarding the differentiation between platforms and ecosystems. I don't know, this has been happening throughout all jurisdictions, but India, which needs to work with the problems of the global south, needs to go deeper into this issue and see that do we have that those large ecosystems which we are comparing to the scaling Indian sort of platforms which are allegedly threatened. So do we really need this? So there are three reasons why I feel that I kind of disagree with the suggestions of the CDCL, is because of different markets cannot be given the same rules, because even in competition law you need to recognize price and non-price factors. Even if you bring up ex ante laws, you will have to get into the technical discussions of how a platform is self-preferencing, how there is ethical or unethical bias over here. So if we do not get into the nuances and the fundamental differences in the concept of platforms and ecosystem, this is hard for CCI. So and that is one. The other is that to go with EU style of regulating is in fact not taking advantage of the fact that that EU was really leading this space, and even US and UK have still not enforced their proposed laws. So why don't we get best of both the worlds, while they are already diving deep into it, and we get the benefit of seeing an impact of how other jurisdictions are investigating the so-called big tech and gatekeepers, and which are creating bottleneck. So per se, ex ante and these protective frameworks do not fundamentally challenge the core issues of platform economy, and contestability and fairness till they are not defined, they are very abstract. Okay, so it will really not be able to CCI will not be able to ultimately make the market very competitive, because what happens is that these structural bigness or structural dominance are not the market barriers today. You have to understand the behavioral aspects. So we are not saying that these large platforms don't have the opportunity to abuse, and there could be abuse. But what about CCI really doing a SWOT analysis and really figuring out, ex ante versus ex post, how is it going to help, and how timely decisions cannot be compromised with quality of enforcement, and therefore to avoid these type of errors, especially the false positives. So while we definitely don't want to overdose at this point of time, we do not want to underdose also just to protect competition, because it doesn't protect competition. How can we strike a balance? So this document could have been a great document for further research, because till you do not define the market, until you do not define what is contestability and fairness, which is very abstract, and you don't do an impact study relating to your own market, it's really not going to, these rules are really not going to minimize market distortion. And the assumption of time efficiency is really questionable if designations and other aspects are all going to be challenged in court, and finally CCI will have to get into the technical decisions which they lack capacity of. So how they can work together with the startup ecosystem and have a techno legal sort of a framework where certain things can be mandatorily obligated after studying the market, that is. So here is where I feel there are fundamental and conceptual problems to legally implement ex-ante laws in India.
Thanks a lot, Anupam. Vivan, before I bring in, Vishy wanted to make a quick point. So Vishy, quickly over to you, your last point, which you had forgotten.
Yeah, sorry, I totally forgot. So therefore, I wrote it down so that never happens. So I actually think that one of the uses of this law, and one of the good things about the law is that they're talking about flexibility. But the problem also lies in the fact that they talk about flexibility. Flexibility is what? Flexibility on what? How do you define the metric on which you determine? I mean, is it consumer welfare? Is it protection of competition? Both of them have two different answers, right? I mean, in terms of what the repercussions are. So therefore, you're ceding the power in the hands of a regulator to define, what is a metric on which this word, is it a good practice or a bad practice, depending upon. And to me, that's the point I wanted to make, which completely slipped my mind. So I'm
just a line to add to this point. I instead of flexibility, I call it intentionally vague. Keeping matters intentionally vague gives them more power.
No, fair enough. I would stick to flexibility if you don't mind, but
Yeah.
that's me. Yeah.
Sorry, I'll have to cut you here and I'll move to Vivan. After Vivan, we'll move to Navneet and Saksham if you have some points, and then we'll go to the next round of questions. Vivan, over to you.
I think Samir has a single finger intervention in case you can allow.
Okay. Yes, Samir, please go ahead.
Sorry. I just actually wanted to understand because I think Anupam mentioned ex ante in some sectors may make sense given if we have the full context. I actually was curious whether the other panelists can interpret this for me. If the Bing search engine, if I go by the current definition in Schedule 1, I think it is an automatic SSED or whatever it is. If Bing had launched in India after being integrated with ChatGPT, which we are all excited about, would that be considered a composite core digital service, or would that be looked at as bundling? How does one unbundle and decide what is core and not? Because to me, that is actually the single biggest flexibility / power and vagueness in the law. Like this whole idea that you can figure out which components are part of the core and which are ancillary is very vague. I'm just curious how you take AI out of the equation the minute you bundle that in.
Thanks, Samir. And Vivan, you go first. And if you would like to respond, and when we come back in the queue, if
The
others...
lawyers can respond in a more
Okay,
scientific
so you go in with what you have to say. Then
technical manner. Yeah. Look, the thing is that I think we're all being very polite. All the discussions that I've seen around this so far, all the commentary, everyone's very polite. We're all well-intentioned, but there are certain things that we need to pay attention to. Maybe we can nuance and refine. But I think the flavor of this discussion has been slightly different from what I've been used to seeing over the last couple of weeks, which is great. I think there seems to be a little bit of a panelist consensus going here, which I didn't expect in terms of just a general skepticism around the need for ex ante, which I think should be the point of departure for most analytical exercises around this. And I think the notion which has come up again of contestability, it's come up prominently in this discussion as being one of the drivers or one of the objectives that we're seeking to achieve here, as opposed to traditional notions related to antitrust, which include obviously consumer welfare and the competition in markets and promotion of that competition. As opposed to that, thinking about this from the point of departure of contestability, it really brings a new frame into view, which is quite antithetical to my ideological bias, which is one of free but regulated markets, where antitrust laws are not supposed to impose a duty on firms to assist competitors or to survive or expand. This is the cornerstone of at least the kind of economics that I subscribe to. And therefore, it is useful to look at this at an ex ante stage from that lens to really interrogate whether this is needed. And if we do, I mean, we take this to its very quick logical conclusion on the schedule that Samir mentioned. We can do a very quick impact assessment. I can run through the 9 intermediary and digital services that are listed here, yeah, and see what this really implies. I mean, what is the and historically we've seen, you know, wherever we have these inclusion exclusion parameters, coming back to your flexibility point, which are vaguely described, there's always the scope for a license raj bargaining conversation that happens, which is really the antithetical to Indian interests in the next 5 to 10 years in the digital space. So at the ex ante stage of analysis, let's not do this to spite Google or Facebook. Okay, let's be clear amongst ourselves. There are people in this room or in the larger you know analytical ecosystem that is informing this exercise, who have some problem with the kind of behavior they feel that they have to navigate vis-a-vis some of the large tech companies. But that doesn't mean you create this catch-all law with 9 categories and you know, you be indiscriminate about the whole exercise. So let's go one by one. Search. Which Indian company is vying for a share of the search market? And to Samir's question, would chat GPT type of services be possible in an over-regulated market? So are we creating the conditions for entrenching search majors, or the model of search and the integration of search with other services that is happening now? Are we entrenching that market power forever by regulating this space in this particular way or not? Social networking. Where is the challenge to you know, the creation of data sets in social networks in India? We have several video and text and perhaps even audio social networking platforms which have over 10 million users. Some have 100 million, some have 300 million. Do they have a problem with access to data? What would they do with access to data from a Facebook or an Instagram or whatever? What would they do with that data that would allow them to monetize better on their platforms? Or is it the case that they need to think about how to promote deregulation conversations in areas that they may not be thinking about actively, for instance, in fintech and payments? Should it not be that we move beyond an OTP dominated world as the RBI, you know, takes 1 step forward, 2 steps backwards every couple of years on this conversation of OTP? But I'm still sitting in my drawing room or balcony trying to catch the OTP when I'm transacting on any Indian or foreign platform. Isn't it easier just to deal with that problem than to create this omnibus law to somehow circumscribe the ability of my competitors to monetize the data that they have, which is not useful to me? VOD, or whatever way they've defined VOD in this. There's 60 registered VOD platforms in the Ministry of Information and Broadcasting. It has a list. There's 60 of them. They're regional, they're national, there are all kinds of VOD that coexist in this Indian market, in this very competitive content market. Conversely, if you go to jurisdictions like Southeast Asia, you will see that VOD market has collapsed despite the absence of you know, any kind of market failure. Here, we actually have a successful market where there is consumption of local content, and yet we have, you know, VOD, which doesn't have any network effects, doesn't have anything related to the kinds of harms that people are positing with respect to these large platforms. That figures in this list. Just shows that it's not a well thought out exercise at all. Messaging. Did Signal, which is like a 30-40% entity, it's a foundation, for God's sake. Telegram is like 20 Russians in a room who have figured out an algorithm where they have brought a quality of service and a privacy metric which attracts consumers and therefore leads them to the business that they have, or the market share that they may have in the messaging market. Agreed, they may not be a advertising behemoth as WhatsApp may be, but certainly one cannot make the case that there's a market entry barrier for them to compete with a WhatsApp, etc., in the messaging market. Operating systems. This is a market that's completely up to the OEMs. If Android, which accounts for 90-95% share of the mobile market in India, firstly, that is not God ordained. This is not the case in the US, where there's a preference for, say, iOS because of the features that iOS brings to the table. Android is an open, semi-open licensing model that it follows. You as an OEM, tomorrow you start a mobile manufacturing outlet, you start a brand, you can go and get the Android license. So again, OS, I don't see where this market entry barrier is coming unless you're thinking of the pure logic of commerce and of consumer welfare as itself being a market entry barrier. If the consumer, for some reason, you want to overcome and plow through the consumer interest here, you want to, that whatever market dynamics have been established, you want to do away with that. You want to create an industrial policy for OS. Okay, be my guest. But I would much rather take the route that Samir and others have taken in the case of the App Store, for instance, which is to try to explore whether it's even possible to do business in a different way in the OS market in India. Has anyone tried except CDAC funded projects? And we know the pitfalls of CDAC digital applications. Web browsers. Did Internet Explorer win? Did it win despite the bundling with the biggest OS in the world in the PC market? No, because there were players who created specialized platforms that were able to gain market share. And over time, of course, that market share settles and things consolidate. And that's the nature of commerce, whether online or offline. Cloud. Did we need even a cloud policy to now become the third or fourth largest cloud destination in the world? We were skeptical about this 5-7 years ago when we felt that the electricity costs in this country are prohibitive and we felt it's too hot to do cloud here, when we felt that we need to create an inorganic supply side push, as we often do, and sometimes it's fueled by people who have an interest in that space. We didn't take the industrial policy approach to cloud, and yet, except perhaps if you look at the financial data, RBI sanction, which I think is valid in the national security and national interest, we don't have a cloud mandate that should have led to, that has led to like a supply side inorganic push. Yet we have cloud everywhere. Every third real estate baron is getting into cloud because they think it's a better rental service than, starting a commercial mall in India today. Why are they doing that if there is a great barrier to entry in cloud? And as far as it relates to strategic partnerships, we just yesterday, Meta and Jio signed a partnership which is visible for all to see. Why did they do that if there is a barrier to Indian firms, working in symbiosis with global firms and so on? Ads. That is the most ridiculous. You can stretch this law. Its most ridiculous aspects come through the fact that if you have a completely unfettered interpretation of how you're going to regulate ads through this law, you are basically killing the version of the Indian internet that is monetizable. You're killing everything on the Indian internet that uses ads. And our politicians and our policymakers, know very well that we are a sort of low cost, market where, we are a high user based market. We're not necessarily a high revenue market. This is known to all. Our per capita income has not jumped exponentially over the last 20 years for us to justify doing away with ads as a reality of the internet, and as something that has actually propelled our app ecosystem growth. And finally, online intermediation. I think we've all talked about it. Where does this stop? This is what we are best at, whether it is real money gaming or it is some other segment of the economy where we actually have local players, where large tech companies are not majors. Why do you want to create this supplicatory ecosystem where Indian companies or foreign companies have to go to yet another regulator or to the same regulator and talk about yet another legislation that they don't understand? I think, look, it's not sexy to talk about basic stuff. Like when we talk about online security and safety, it's not sexy to talk about the fact that, we need this in schools, we need more education, we need CBSE to be doing more, we need course curriculum. These are the basics, 101 of how we will have a more cyber secure Indian internet. Similarly, how will we have a more how will we have a more responsive antitrust regime? We'll have to build capacity of the CCI. And also, as far as consumer welfare is concerned, we'll have to enable courts, as Mr. Pingali was saying. Not everyone has students who are working in large technology companies are going to give the grievance redressal. But do any of us dare to approach the courts for anything if it's not an existential matter? No, we don't. But it's not sexy for us to say this in a conversation on tech policy, because let's be honest, all of us in some way or the other benefit from the tech policy conversation, perhaps other than Samir, who is unfortunately a victim of it. I'll leave it at that. I have a lot more to say.
Thanks, Vivan. And before I bring in Navneet, Meghna, if it's a quick intervention, over to
very quick, very quick. Just on the success of ex-ante regulation. So first off, in telecom, you have forbearance, which means that for all intents and purposes, even at least from the standpoint of price regulation, there is none. And both those things that were mentioned, both telecom and electricity, are utilities. I understand that this is also an extension of the essential facilities doctrine to the online space, but I think the jury's out on whether these would qualify as utilities. And just again on the success of telecom regulation, particularly in broadcasting, because it's a sector I'm familiar with, I used to work in. Through 16 years of regulation that the TRAI has, that the TRAI has governed broadcasting, there have been multiple litigations. So, I have data from 2019. There were at least 12 cases against TRAI regulation in the High Courts and the Supreme Courts in 2019. Similarly, since TRAI has come in, the number of petitions filed before the TDSAT. So in 2018, there were 971 in broadcasting, and in 2019, there were 696. So to say that the introduction of ex-ante regulation will reduce, the time spent in court or the time required for the finality of a matter is totally false. That is another thing in this regulation in this law, that there is no scope for appeal from the regulatory orders of the CCI. That is another thing altogether, also problematic. But basically, what you're going to have is just the CCI in court with multiple companies over many years. You're not going to see finality. You are going to see market failure. You are going to see multiple entities, particularly when a regulator regulates two sides of a market, which is what is also happening in broadcasting. You are going to see if one side is unhappy, they will go to court. If the other side is unhappy, they will go to court. So this whole argument that, we need this law because market is too fast moving and we are too slow, I think is moot when you look at the experience of ex-ante regulation, but of a two-sided market in this country. That's all I have to say.
Thank you so much, Meghna. And Navneet, over to you, as in from CIRC, Cuts per se has been looking at consumer interests, but you have always been doing a lot of research on competition. So how are you looking at this draft, and what are your, and you've heard the other speakers also.
Thank you, Amrita, firstly for inviting Cuts to this meeting, and I have very keenly heard all the panelists, and I quite enjoyed the specific examples of Samir. And I understand you will follow it with another brief round, even though time is not there, but I will try to attach some first principles so that we can organize our thoughts. And my humble effort in this round is to attach some first principles so that our responses can be slightly better organized or sharpened. So for that, I have organized my own thoughts in 4 or 5 buckets. So first is, let's ask the question, what exactly is the purpose of digital competition bill? In one line, even if it is not mentioned in these many words, I completely agree with Samir that the core problem is entry barrier, right? So therefore, to restore competition, we already have Competition Act 2002, right? So post facto, whatever has happened, we can restore competition, whether it works, do not work, etc. Those are different questions. But the primary purpose of this bill is to trigger competition. It is not to restore competition. That is what we are trying to achieve, right? Let's have these two streams running parallelly so that we can understand the value add delivered by an ex ante law vis-a-vis the existing law. So that's my first comment. The second is, how does it fit in India's quest for Viksit Bharat? Let us agree that ex ante law is not an end unto itself. It is a small, puny little instrument to achieve that larger objective. We have a country, we have our social problems, economic problems, and we have a new format of business called digital economy. Therefore, how do we organize that in a manner that the larger welfare macroeconomic goals are achieved? That is so for that, let us for a moment don't adopt a myopic view and just talk about digital economy. I mean, I would like to remind everyone here that the industry 4.0 sees digital as an integral part. So therefore, there is a lot of manufacturing which will have digital interface in some manner or the other. So let's not get too bogged down by the services part of the digital economy. There's a lot to it. There's tech to it, there's product to it, there's services to it. So then the second point is the startup and micro and small enterprises. Particularly, they need to have, which is an extremely critical point, that they need to have easy and affordable access to markets. Some of the, some of the categories listed in the Schedule 1, I mean, that is where the easy and affordable access to market is the principle we need to watch out. Then thirdly, let's not miss out in this debate that to reap the great demographic dividend, we need an enabling framework of digital economy regulation. I mean, all of this is subservient to that. It's not the other way around. So therefore, therefore the question is, have we done adequate groundwork? And I tend to agree with Samir that 6 months is something I see very realistic span of consultation to really consider all the relevant aspects. The question is, have we done adequate groundwork to make a choice which may come with some lock-in effects? And I want to draw your attention to some unrelated examples. Let's say for foreign trade agreements, we made certain choices early 2000 and subsequent in that decade that led to lock-in effect, and we continue to bleed. So therefore, are we ready to have a regulatory policy, a regulatory design which comes with some kind of lock-in, and then subsequently we create a jhanjat, and then now we clean the jhanjat, right? So therefore, let's agree that question is an important one, and therefore we need to have some amount of deliberation there. My third bucket is that of the design aspect. What is the architecture design of this law? And that's where my next question, issue of regulatory capacity will come in. All of us know that regulatory markets evolve very, very fast. They can tip very fast. All this is written in the report of the committee also. And there is a considerable detail which the committee has gone, and I certainly want to compliment for those details. But there are more questions which we need to think. So therefore, for a fast evolving law, by design, we need to draft a law which is incomplete. Because if you draft a complete law, it will become incomplete very soon. So by design, we need an incomplete law, right? It's an extremely sensitive point, and I would request attention of the House here that, and when you design an incomplete law, I mean, it is very natural to have these adjectives, fair, and transparent, and non-discriminatory, and what is integral and what is not integral, Samir. That's really a fascinating question that when you are designing a portal, then when you are designing a product, on what principles do you decide that this is integral and this is alienable and this is inalienable? Who decides? On what principles? So therefore, these adjectives are there. The incompleteness here is designed to enable speedy enforcement. Let's go back to the slide number 1 Saksham presented. That why do we need this law? Because we need a speedy enforcement of whatever challenges, or if you like the term, Vivan, market failure, you're an economist, so whatever term you like, That is what is the central aspect we are trying to address. And therefore arises the next question. Having explained to you very briefly the design aspect, comes the question, from this very design emanates the need of a great regulatory competence. Because when you have something which is very formulaic, formula-based, something which is very prescriptive, it is, I mean, this law requires an engineer which can repair an aircraft while it is still flying. That is the kind of analogy, that is the kind of regulatory superpower one will require to enforce this incomplete law. So when, all of us know Competition Act had only one ex ante, that was merger, and rest was ex post. This law is not axiomatic, Professor Vishwanath, if you allow me to borrow a term from our academic parlance, which means it's not self-evident. It's not a self-evident affair. So therefore, when it is non-axiomatic, there is no textbook. The standard economic theories which you have read in thousands of orders of India and your EU and your US or wherever, that there is no standard textbook economic answer to the issues you're trying to address. The decisions are very much discretionary, selective, and non-formulaic, because you're trying to address something not in a Competition Act manner, but in an ex-ante manner, right? So therefore, when you are trying to do this, the question emerges is that if CCI has the sufficient staffing at all levels to really deal with this kind of discretionary but strategic policy making. I mean, if all of this goes to the commission, then again, it's a different question. So therefore, the question of regulatory, capacity. And before I stop, and in the next segment, I will be happy to take up share some research on how this kind of a law can affect users or consumers, whatever term. But before I stop, I want to mention one last point that, and Samir, I need your attention here, that let's agree that it's not about fines and deterrence, because that's already there in the existing law, isn't it? We have revised it also. If that medicine were working, why are we talking about a new medicine? So therefore, let's agree that in principle, it is not about fines. And even though there are sections about investigation, there are sections about penalties and appeals and everything. But let's, as a matter of principle, agree that it is not about all that, because all that is existing in the Competition Act 2002. This law is about something else. This law is about compliance. And that compliance, the nature of the animal is such that compliance, of course, that will require a regular back and forth between SSDEs and the commission. So in that process, how that compliance will be established, it will be a little naive to say that the compliance is largely with the business. No, businesses will come up with their solutions. Ultimately, the commission will have to approve, and then only we will see that the effective, quick, and efficient remedy is emerging, right? So that is, therefore, the design, the regulatory requirement, and how the effective, how it will really get manifested in terms of enforcement are the three interrelated points we have to consider before really, examining specific proposals like designation thresholds or the schedule or the restrictions. I'll stop here, Amrita, and happy to come back again. Thank you very much.
Thank you, Navneet. And what we would do is, I see we have 30 minutes. We may have to stretch for another 15 minutes over the 6 p.m. if it's okay with all. I will first go to Saksham, and Saksham, I see your hand up, and then Samir's. But what we will do is we'll reverse the order now. So Saksham, if you want to respond to this, that's great. And if you want to also share what is the next, how do you see the way forward?
Actually, my comments are on way forward, Amrita. So I would rather that Samir goes first, and then I can, we can then start
Samir,
the way forward.
Since you want to intervene.
Yeah, 30-second response to the last point Navneet brought up. I think to seed the fact or the point that the medicine is not working and therefore we must enter the territory of ex ante is very dangerous. I would submit here, sir, that the doctor doesn't know how to prescribe the medicine or do the diagnosis. You're solving the wrong problem here. We did a lot of work in a lot of recent CCI matters, both on Play Store, App Store, and I have tons of friends at Google and Apple, and I told them the problem was they were not able to get to the material in time. The initial set of submissions that went up, and they're still with NCLAT, right? And we're part of the lawsuits with Indus, with MapMy India, all the way up to Supreme Court. And I can tell you this, if the doctor's prescribing the medicine for this industry and you want to give them ex ante powers, maybe a better start, maybe to have them have an office set up here. I work in a very regulated financial services sector, and even the Reserve Bank of India has put up 5 kilometers from Outer Ring Road, where 1,000 fintechs work. They put up the innovation hub in Bangalore. CCI doesn't have an office here that I'm aware of. And if they're trying to understand how tech multipliers and network effects, etc., work, it is imperative that they have a team on the ground understanding new trends. This is why I gave the example of ChatGPT, which we're all celebrating, kind of confused about, coming from the same company that's making Bing, right? I just think it's very dangerous to say, let's give up on what actually should have been the answer, which is coming up with the right method and a well-empowered CCI and well-equipped CCI and walk straight into ex ante. Because if we are seeding that first point, this conversation is largely null and void, because they'll just open up that section 9 in schedule 1 and just include everybody that they deem fit. If you're giving them open-ended discretion, if I can't go to the Supreme Court if I disagree, as a startup, I might as well just go set up in Cayman Islands or Ireland again. I think that's ceding too much ground.
Right. Thank you, Samir. Saksham, over to you. As in, you've been hearing all the conversations, you gave the brief overview. So what do we do now? What next? As in, what should, do you think?
I mean, tall tasks today for me to first summarize in 10 minutes and now start this conversation on solutions. But no, I think it's important, and I've been saying that for a while now, that the conversation needs to be forward-looking, right? And this is me talking as a pragmatist and not as an idealist. Of course, if I talk as an idealist, we should go back to the drawing board and do the problem context setting all over again. From what I've heard today and from what I've been reading also, a lot of these conversations were happening earlier, maybe were not heard, or maybe were not happening earlier, I'm not sure. But the problem of two levels, and I spoke about this at a CIS event also, where a lot of my fellow panelists were also there. Priority setting did not happen in time, I mean, do we have to prioritize digital markets under competition frameworks right now, or are there other sectors that need the CCI's attention? I'm not sure if labor markets deserve that attention or not, but did they get that consideration or not? Yeah. If there are other sectors which require attention, did that come up in the agendas or not? Or did we straight away jump to digital markets? Why? Because maybe the world is doing it, right? Because the CCI is a part of ICN is a part of UNCTAD. There are all these multilateral forums, there's international geopolitical, face keeping you have to do, but whatever the reasons might be. So we jumped to digital markets as a priority, first of all. Then when we came to problem context setting, again, it's under panel today and the conversation today and the past few years is representative of how the conversation has been developed in the past few years. For some people and for the CCI, maybe the problem context is contestability horizontally. For some, the problem context is vertical harms that are happening to downstream players. For some, the problem should have been consumer welfare, right? So those conversations should have happened earlier, but there might be scope to do them earlier, to do them now, right? So where do we go from here? Multiple points where my humble submissions are. Now, as I also said earlier, and I've been saying this for a while now, that contrary to what the government might think, this is not a sprint, it's a marathon, right? Whatever has been done in the past 1 year, going forward, what we have to is that we have to be more patient, right? And there is, of course, some consensus I see on the panel today that we do need more time. So it goes without saying, I wouldn't reiterate it that, we do need more time for this consultation period. But as in when this consultation period ends, 1 month, 3 months, if we listen to Samir, then maybe 6 months, that's not going to be the end of it, right? We should be asking for more steps. We should be asking for the updated bill as in when it's ready after public comments. So we refer back to the Parliamentary Standing Committee on Finance, right? so that they can again assess it, again call more people to depose. We should be asking for impact assessment reports, right? Impact assessments can be at any level. We discussed this at the CIS event. Can be impact on markets, can be impact on the regulatory framework, impact on capacity of the CCI. The possibilities are endless. We should be pushing for those. We should be pushing for, I don't know, capacity building sessions. Why not go out of the way to do more capacity building sessions? We keep saying that, there is very little awareness among day-to-day consumers and smaller players, like the smallest of players, about what this mess is even about. What is digital competition law all about? So capacity building, referring the PSC report back to, referring the bill back to the PSC impact assessment. So we need to set up we may need to set up certain interventions at every level to make sure that we have enough evidence and enough assessment, right? That's number one. Second is capacity. And again, I don't think anyone in the room disagrees with me that capacity is the need of the hour, right? But on this point, I've always said that I would not like to, I actually would commend CCI on some of the work it's done. And I said this on last panel also, that considering the mandates it has on anti-profiteering, advocacy, enforcement, everything under the sun, expecting it to do what it's been doing, and now expecting it to come out with regulations on like a dozen things which is under this law is impossible, right? So, kudos to the CCI for having been able to pull off what it's been able to pull off till now in traditional markets, goes without saying. But going forward, you have to build capacity. What capacity means, we had a discussion earlier a few weeks ago, some brilliant ideas, that came up. Of course, maybe do you want to bring in some private sector players to bring in some technical capacity from the technical ecosystem, right? Some engineers, some CXOs to come in, while of course guarding against the risk of regulatory capture and looking at the revolving door policy very carefully. But do we need to bring in private experts? Do we need to bring in more academia, more economists, right? Everybody talks about more technologists coming to the commission. I don't believe honestly that there are enough economists, true economists who do hard economic analysis in the CCI day in, day out. So do we need to bring them more in? Increase the numbers. The buck stops with resources, to be honest. No matter how you slice it, you need more money. If I am not wrong, the budget last year was around 54 crores, right? Compare that with the SEBI's budget, compare that with RBI's budget, compare that with any global south jurisdiction's budget. I'm not even comparing with EU or US. Compare it with the global south. It's nothing. So you need more money. It's a simple fact. You need more money, you need more people, you need more expertise. And then lastly, I'm not going into the nuances of, enough has been spoken about the scope of Schedule 1, time and bundling, data usage, etc., etc. Of course, they need to be reassessed. They need to be looked at as we go ahead over the next few months. Third would be, of course, bringing in a wider stakeholder group, right? And I think I personally would feel that everyone in civil society, everyone in the government, everyone in industry is slightly responsible for this. It's not only the government's mandate. It is the government's mandate primarily, but we all need to make sure that there is a wider stakeholder group involved, right? So government, especially going forward, and all of us need to bring in gig workers into the conversation, right? There are organizations like AIGWU. There are, I think, ITUT, if I'm not wrong. There are organizations, bring them into the conversation. There are consumer bodies. Tuts is here as as an organization who have done brilliant work with grassroots consumers over the past few decades. They should have more say in what's happening, right? So a wider stakeholder net. And then lastly, interregulatory coordination. That's my personal pain point. I will not be able to analyze the digital protection, the DPDP Act as it intersects with DCA, as it intersects with DIA, as it intersects with FDI, with e-commerce. It's a loop. It's a loop. It will throw me for a loop, right? So, and I'm not even suggesting what to do about it. I think we are all in the learning stage. No one can come up and tell me tomorrow or tell us tomorrow that this is what you do to separate the guardrails or to separate the lines between different laws. All I'm saying is set up the mechanisms to set up these guardrails, right? What do you need? Do you need a high-level committee at the cabinet level? Do you need another committee where different people are delegated? Do you need MATI members to be sitting with the CCI? Do you need DPIIT people to be sitting with the CCI? I'm not sure. Some of it is covered in our report, but set up the mechanisms. So that's where my submission end for the day is that, of course, more time, everyone agrees. Capacity, interrelated coordination, and to be honest, certain principles that are enshrined there, how do you tweak them? They're not going away anywhere, but how do you tweak them, right? To make sure that you're regulating what you want to regulate and not catching unnecessary conduct which is not prone to competition harm right now. So that's my piece.
Thank you, Saksham. And just to everyone, as I mentioned in the chat, we may go over 15 minutes if that's okay. And so I'll go to Navneet. And I see Mr. Augustine Peter also here. Perhaps during the open session, we would like to hear from you, sir, if you have some comments. But we'll first go to Navneet to share, what could be the way forward? How do we go about it from here? Now that we have something, and I think, and people may correct me, this is the first time there is such consultation on the competition bill which is happening. In fact, many of us from civil society and others had written that there should be more stakeholder consultation when CDCL was coming up with this. So let's hope that they give an extension and at least 3 months, if not 6 months, for more deliberation. But we live in hope. But Navneet, over to you.
So I heard Saksham what specific point he made. I want to add to that list that first is, I think, and that I relate with Sameer's earlier comment, that there are businesses of variety of sizes. We have micro enterprises, we have small enterprises, we have startups, and we have big startups, we have unicorns, we have very, very big companies. Examples of Tata Neu and Jio, and several were mentioned in the preceding comments. So first is, I think, the impact on businesses, both Indian businesses as well as businesses of foreign origin, because we need a full ecosystem. So therefore, I think that is the first area of impact assessment, where some of it can be done by businesses, some of it can be done by governments, some of it can be done by associations, but we need much clearer understanding of the impact on businesses. That's my first point, because see the kind of restrictions you're bringing, and to clarify, Sameer, I didn't cede any space. I was only saying that this is a law which comes with a specific design, therefore which comes with a specific challenges. And if we don't understand those linkages, we will not be able to really raise right questions. So therefore, the first, for instance, for the business now, there are no scientific answers. What is right, what is bad, what bundling works, what bundling is bad. There are empirical studies. There are empirical studies about investment. Professor Pingali would be happy to share those details with you, how certain regulatory interventions attract or detract investments, etc. Right? So, but first question is, if you make businesses busy in this, you are basically taking them away from investment, innovation. Therefore, empirically, we need more data from not only from India, but also from Europe, particularly, rate of new product launches, for example, new features added to the product, prices. We need empirical data on this so that we know this medicine works, right? That's my first point. The second point I want to mention is, again, an impact assessment area, that is the consumer impact. We have done some work in this area, and I can say some of it you heard from Meghna's presentation, where she studied micro and small enterprises. Here we looked at individual users' experiences in terms of, let's say, multiple sign-ons. So now, if you are having basically the integratedness of the product is what generates a great user experience. Sameer has a great product. I would request him to throw some light on product design, so that when you unbundle, when you untie it, what happens or what can happen is a question we would love to learn your thoughts on. So therefore, first is disintegration of products, right? The second is unbundling because of that, and that implies that the capability to offer multiple interconnected services within a single application will be limited. And once you do that, it is a speculation. I can say that there is a good chance that this unbundling process might have implications for convenience, user experience, pricing, and so on. Right? So therefore, we need more work on these areas. It's little presumptive to say this is bad and therefore this needs to be corrected. We need research on this, basically. Now, for example, we see, let's say, Article 10, we read this language fair, non-discriminatory, transparently manner that an SSD will have to deal with end users and business users. This would mean that a designated entity may be prohibited to enter into exclusive tie-ups, for example. As a result, I mean, there is enough empirical evidence that exclusive tie-ups do deliver some benefit. Do we want to foreclose all of that? Or we want to address the tie-ups which are clear in terms of delivering adverse impacts? Are we making a distinction or are we not making a distinction is a question both lawyers, economists must very carefully look at. One more, for example, the users may encounter increased frequency of pop-ups and notifications. And we have sufficient studies now from Europe where we have seen how consent fatigue has led to, practically either insignificant or no benefits to the users. Even though the law is there, even though the full compliance is there, but has the user benefited is a big question still, despite of several years of regulatory enforcement in this area. So therefore, I think we need all these questions in terms of impact on variety of sizes of businesses, impact on different categories of users or consumers. I think these are big areas and we definitely need more time to do that. Just a small last trivial point to be made. I wish the data was defined in the list of definitions, but I'll stop here. Thank you.
Thank you so much, Navneet. And Vivan, over to you.
Yeah, thank you. Few principles that I would look at in the context of digital regulation and antitrust is don't penalize size. A lot of companies that are going to be able to compete with the so-called big tech companies are also going to have to be necessarily large. I mean, a Meta trying to challenge Twitter with threads is one example. There are countless examples like this. Second is to incentivize innovation, and antitrust doesn't necessarily manage to do that in fast-moving digital markets or in other analogous markets like financial sector, for instance. But regulatory certainty does. So why don't we double down on figuring out a safe harbor for innovation across various segments of the digital space where our innovators and entrepreneurs are busy at work? Why don't we prioritize those regulations? And we've also seen actually that just to belabor this point on antitrust doesn't necessarily incentivize innovation in this market, but what we do have evidence of safe harbor in the form of the Communications Decency Act actually leading to the Cambrian explosion of intermediaries. And we have, that is the most definitive evidence of regulatory certainty and predictability providing lever for innovation, as opposed to the kind of unpredictability that's baked into discretionary antitrust frameworks like this that are Europe inspired. Don't create a workforce of compliance professionals. I don't think we need any more consultants and Deloittes and KPMGs and so on and so forth. We need more innovation. What we're doing here and what we see from Europe and what a lot of evangelists of this approach of ex ante say that there's now a global consensus. In fact, an economist that I respect a lot recently wrote in Indian Express saying there's a global consensus and therefore they create space for us to act this way, and it's strategic to act this way. But I would argue the exact opposite. It's strategic not to act this way. It's strategic to make our own way and see the clear impetus to do so. And finally, I would say stakeholder responsibility is not something that large or big companies in any segment of the economy should shun. They should embrace it. We are a developing country. We require obviously the profit motive to coexist with a sense of larger societal engagement which uplifts everybody. So let nobody be expropriatory. Just because some of us are arguing for free market doesn't mean that we want expropriatory companies to be operating here, and it should not be anyone's case that is in the national interest or even our personal individual career interests. And I think let that also be the stakeholder responsibility in a sense of the legal community, which does have a bias coming into this conversation, because every time you start an op-ed or a research paper or a project, the kind of citations and references that you will readily refer to do tend to be from Europe or Lina Khan or other exponents of this new approach that has emerged globally, whereas you ignore like 70, 80, 100 years of economic literature which states the exact opposite. So I think there's a responsibility for all of us in the legal research, economic research community not to be swayed by the first citations we see by Google, even though it's not trying to self-reference. So let's not over-rely on the same services to do our research. Let's get out there, talk to people, and make our own conclusions and our own path.
Thanks, Vivan. Anupam, over to you.
Sure. So the post-DMA investigations have already started as on 25th March against Alphabet, Apple, and Meta, using that as base to showcase how there is so much lack of clarity even in how DMA is challenging the compliance reports of these companies, and the choice screens and all those aspects which they have challenged. There is lack of clarity. And therefore, using that, I think it's the Indian startup ecosystem can definitely make it a good case and get up towards, challenging this report and, for an alternative view, for an alternative proposal. But we know that, CCI has unprecedented power, especially with the anti-circumvention provision, which they have also adopted from EU. And here, the other disadvantage is that in India, we cannot challenge policies. In EU, you can still go against, a state which is taking certain favors or certain matters in their favor. So here is where a huge reason or ground for the Indian startup ecosystem to really put up their case over here, and they need to do it proactively, because obviously somewhere we see a fragmentation in the report. If you see, there are so many players which have, which stakeholders which have said they are in favor of ex-ante, including NASSCOM. And so it gives the impression that, and if I'm not wrong, even Esya Centre, Meghna, you can correct me if I'm wrong, but thing is that it gives an impression that we are not expecting the Indian players are not expecting to grow that big. And therefore, they want the Googles and the GAFANs of this world to be regulated, and they feel that the core digital services, for which the regulations will be framed later on, that time we'll see what happens to us. So the reason to propose an alternative approach definitely is lack of clarity in the design principles, as one can also see how even the 3 companies which are being investigated are also suffering from. So what are the first principles based on which they need to design their product, and how can they offer user experience? Like I said in the beginning, that the ex-ante laws do not appreciate the difference between offering products and services as value creation, and therefore bundling is being confused with complementarity being given in an efficient and ethical way to something bad. So therefore, I agree with Samir also that core digital services can be confused with, Bing can be confused with ChatGPT. It is broad enough to interpret that whether the two are being bundled, and definitely this is going to go against the platform players or the digital platforms to diversify, because that's the only way. Even traditionally you have conglomerates, but on the digital platform, you definitely need to diversify to be able to the 2 sides, 3 sides, or more sides, to be able to monetize your business model. So the appeal can be that this is not a pragmatic proposal, because this is killing the market rather than giving an incentive. So what is the incentive for us to comply? A, there's lack of clarity. B, it's not pragmatic. It doesn't understand a business model. It doesn't understand product design, the user experience, and asking for a regulatory impact analysis for good reasons first. So the onus should be on the CCI to engage with more stakeholders, provided the stakeholders are not fragmented, like I said. And as far as the sector-specific overlapping is concerned, I agree with Saksham that they've just mentioned it to give a reason to say that, okay, these other laws are not dealing with competition, so we need to deal with competition, not realizing or not talking about the fact that their objectives is different. That's why I said that ex ante laws in certain sectors or at a certain time when you needed to liberalize for certain sector specific regulations required opening up the market. So therefore it made sense, but it doesn't make sense to go across all sectors and have similar rules for different business models. So it's like regulating apples market to oranges market, and therefore it's not making sense at all. Whether it's making sense to you and others, we in the global south are really at a stage of growth, and therefore it will definitely kill the existing unicorns and the budding unicorns, provided again we need to be proactive and to showcase that yes, we are expecting to grow that big, and therefore we don't want to be killed. So I think that's where the key to changing the view would lie, according to me.
Thank you, Anupam. Thank you so much, and Rishi, over to you now.
Amrita, I know it's been a long discussion, so I'm sorry for making it a little pedantic. There's a paper that came out in Information Science Review 2024 February. That is like, when I'm speaking, the ink on the paper is not yet dried out, right? And that's how latest this paper is. When people try to regulate the prices on a digital platform, it's a small businesses that disproportionately suffered when compared to large businesses. Enough said about ex ante, right? I mean, so that's all I stand for. The second point is, I need to cite Ujjwal's comment out here in the chat as well. When you talk about consumer and digital market, I am afraid you really talk only about end consumer. End consumer is not the only consumer. Platform, by definition, means the two sides of the parties meet. So therefore, businesses as well as the end consumers are the consumers on the platform. So therefore, anything that impacts one side or the other side is going to destroy the delicate balance that the platform tries to maintain. And therefore, we need to be extremely careful about that in terms of regulation. So therefore, my two probable bullet points are, and I'm really going to stop after that. One, we need really more time to think through. Two, local evidence for local problems. I think I can't stress more on this. Along with teaching microeconomics at IIM Ahmedabad, I also moonlight as a behavioral economist. So therefore, ex ante regulation relies a lot on the rationality assumptions that you make in a standard game theory class. Behavioral economics tells you that many of those rationality assumptions don't work. Please ask Daniel Kahneman, God bless his soul. Right, so I'll stop there for the time being. But that's all my views on the matter.
Thank you, Rishi. Samir, would you like to go next?
Sure. Yeah, I think in closing, I think the way this, even if I start with where Navneet left off, just going to the motivations of the ex ante sort of law, I think one thing seems clear in just the law itself. I don't think we are solving for the consumer side, like what's good by the consumer, because I don't think there's anyone who's ever argued Google's too expensive, their services are not good, or anyone in the vanguard, right? We all use all these products. So I don't think it's a direct consumer harm argument. I think the societal impact, and this is playing out more in the US than Europe. Europe just keeps talking about like pop-ups. I ignore them. But in the US, I think there's a lot more impact that's happening on the smaller businesses because they're getting concentrated out. And I think ex-ante is coming in with the view of saying, don't prioritize your food over your restaurant's food or your sellers over your fashion or whatever it might be, right? I think that's really where a lot of this build-up's coming from. And so if we're clear that we are trying to make sure that the markets are competitive, and that's really the focus, let's call it out. Let's stop pretending that this has anything to do with the consumer. To make this a little more interesting, to land the point, I'll give you our real world example from where we started. We launched the same day as this little known brand called UPI, which today I think everyone knows. We've amplified the hell out of it. When we started out with this body called NPCI, which again was known but less known. I think everyone here would know what an NPCI is today. When it started out, the ask was promote as extensively as possible, penetrate India as much as possible, solve for inclusion, market. We used to get calls saying, why aren't you incentivizing enough? Why aren't you promoting it enough? Can you go to the hills? Government department after government departments given subsidies to go into the hilly areas, into rural India, into Kashmir and what have you. Somewhere along the line, when the discussion of sort of getting monetization going started, the government came and said, don't charge. This is a utility service. This is all pervasive. So first they said, okay, nobody in the ecosystem in the private sector can charge consumers or merchants. And it really was merchants because they were the ones who were paying for this. Well and good. How do we make money? They said there's this treasure trove of data, sell financial products. The regulator on the other side says, don't use the data, right? There is this sort of gap where one is saying the consumer is sacred, it's their data, it's the merchant's data, you can't use the data. And the other is actually saying, monetize, you have data, the data can be used for advertising, for upselling financial products, cross-selling e-commerce products, right? I'm giving that one angle of just MDR, many of you might have heard about this, versus what you charge for and whom you charge. Now, same thing's happening at the platforms level at a broader scale. The Digital Privacy Act says without talking to the consumer and getting consent for every application of the permission you take. If I ask you for your location back in the day, I asked you for your location when you were booking a cab. At that point of time, it was relevant only in terms of helping you figure out the best navigation. 5 years later, Ola might be able to actually give you better car insurance or whatever insurance as an upsell, or Uber might, or whoever. Or Uber Treats might be able to actually tell you if there's deals happening in your neighborhood. The second and third use of data is now illegal unless I pop another pop-up back at you and ask you, can I use this data for that purpose? So yet again, you have one more law, which is basically interpreting whether you have the consent for the purpose. And yet again, you have one regulator who's going to come in and interpret whether this was right. And yet again, you have a whole bunch of startups who are scared, and the product managers and the designers are thinking about, am I building right by the consumer? No, they've stopped thinking about that. I can tell you, this is like peak stupid right now. The conversations that young developers are having in the Indian startup ecosystem are about, will this fit right by the privacy bill? Will this fit by the regulator? Will this fit right by the DPIs? Everyone is coming and saying, you can't do this, you can't do this, you can't do this. Nobody owns or has accountability for saying, this is how we think you can legitimately make money. Now, they need to also think about that when they're talking about ex-ante regulations. How about then coming out and saying, these are the legitimate uses I can tell you today and they will apply for the next 10 years. Don't tell me 5 years later, there'll be a 50% or 30% market cap on a PhonePe and a Google Pay after we've invested billions of dollars creating the damn UPI market that you're celebrating. I think it's perverse. I think it's wrong for a billion of us to use Google search and then come out and say, oh, Google search is a monopoly, they're making too much money on ads. That's not the problem. The problem is, to Vivan's point, none of us are bothering to challenge them. Let's build a great search engine. Let us allow people to innovate without trying to pass all this literature around fair and ethical use of AI. When we have a Sam Altman coming down to India, oh my God, it's a red carpet party, right? Everybody wants to opine and rub shoulders with them about what the future is going to look like. If an Indian startup comes up with an AI solution, I guarantee you they'll get slammed with so much regulation and so many big fours and every other think tank out there. They don't even want to enter the discourse right now. That's the problem. You'd rather work sitting in India for a Microsoft or a OpenGPT, because then you can do cutting edge work without having to deal with the idiosyncrasy of the market. We need to have a principled discussion, not just about how low can we keep the cost of servicing 1.4 billion people using digital technology, which should be the only core focus for the next 20 years. But along with that, how do we make sure we are creating a sustainable and ethical ecosystem? The word sustainable is missing over and over and over. This is yet one more body getting armed with powers to say, I don't allow you to do X, Y, Z. This is where they should take a cue from financial regulators who also introduce fair pricing. They also introduce minimum pricing in certain cases. Learn from the IRDAs and the SEBIs and the others. This is very important. If CCI is basically going to become the regulator of the internet sector, which is essentially what we're giving them power to do, and have all the discretion, they need to also come out and say, what are you allowed to do, and codify that. If we can achieve that, I don't care if we call him CCI, we just basically created the first true internet regulator in the world. I think I personally feel, I could be wrong. I think it's a fool's notion because technology advances way faster than anyone trying to regulate in that sense. But at least try and bring that into the discussion so people realize how hard it is for startups trying to innovate in India. We are getting squeezed. Anything that's going to scale, they're calling a DPI. And the government doesn't have to follow the same rules. Anything that's coming from abroad has so much bottom line cushion that they can play the game for ever and ever and ever. In between are the startups who are using private equity money and wasting it on law firms. It's kind of tragic. We need to fix this. So I would actually say that if we are making a representation, one part of the representation should be that in this case, the law must clearly specify what is permitted activity, along with saying that this is not permitted. If you're allowed to say that this is not permitted, you must clarify what is permitted.
Thank you, Samir. I think the clarity is very essential for, the aspirations we have of, having the largest startup economy, etc., or becoming what we want to, the government's aim is. Meghna, over to you.
Yeah, so just to clarify, although our view was represented in the CDCL report as being pro ex ante, that is not what we said to them, and we will be clarifying that or requesting a clarification or a correction of that record in our response to them. We said, do not do ex ante, but if you are going to do it anyway, then do these things. And one of those things was basically build institutional capacity of CCI. There's been a lot of chat in the chat about consumer welfare. And that I think is a great omission both in this report and even in the, it reflects in the provisions of the bill. And even in conversations around, Vivan mentioned Lina Khan, basically this neo-Brandeisian movement of antitrust, which says, or which advocates for a movement away from the consumer welfare standard, because the consumer welfare standard pertains to price, which becomes a non-factor when you're dealing with basically free services online. But my contention to that is there are enough indications, and of course the converse of that is that they have brought in things like privacy. That privacy is an aspect of consumer welfare, so non-price factors related to consumer welfare. I think there is a much there's greater research that has to be done there. So we've done some research with consumers as well, considering the impacts of this bill on consumers. And what we found is that consumers like targeting. They like what the benefits they receive from targeted advertising, which goes against the notion of privacy being pro-consumer welfare. Consumers are also willing to pay between 5 and 20% more on platforms that basically control the end-to-end transaction experience for them. So they provide them transaction security, they provide them with security against fraud, etc., and invest in those resources, which this law seeks to unbundle. So my, short recommendation would be to do away with this bill entirely and wait and watch and see the market failures transpire in the EU with the DMA, as we have seen with the GDPR. 5 years after the GDPR came out, there were multiple empirical studies that showed that startups fell by the wayside. Consumers felt like their data wasn't that it didn't have an overarching sense of greater privacy protection. They were also suffering from great consent fatigue. And if the GDPR was leading to consent fatigue, this will be a whole other level. I mean, some of the other panelists have touched upon this, that basically there is such an extreme disaggregation of the product experience that and basically that at every stage you will be asked for a consent, for your consent. And that actually brings me to the other point, is that what is the merit in a law which basically interferes with product design? And I think Sameer touched upon this, that, tell us what we can do. I don't think that it is a regulator's place or a legislator's place to be telling businesses what they can do, how they can design their products, because that is antithetical to the notion of innovation, which is something that this law purportedly tries to promote and safeguard. So yeah, those are some of the things that I recommend. I recommend that we wait and watch for the inevitable market failures. One more thing, I think, because we've spoken a lot about search, and I think this is an interesting anecdote that maybe not many people know about. India did have a search engine. It was called Guruji.com, and it had received, this is before we had our safe harbor provision under the IT Act. It was called Guruji.com. It was particularly well known for music search. And, it had received investment from Sequoia, etc., etc. It was on its way. And essentially what happened is it got a copyright lawsuit slapped on it because people were using it to find to download pirated files of music, or to find pirated files of music. So Tips filed a copyright lawsuit against it. The CEO was arrested, and that had a chilling effect, and it was shuttered. And this was, the primary reason why this happened was because we did not have a safe harbor law that protected the platform from what users did on it. So I think, just to Vivan's point, the absence of regulatory certainty is more harmful than the presence of it. This law does nothing to bolster certainty or to afford certainty to any of the stakeholders that it affects. In fact, it adds an incredible amount of uncertainty and ambiguity in terms of what the future of a business is. Now, where is the CCI going to decide what is integral to my business? And if the CCI considers it anti-competitive, but it is integral to my business and my business cannot run without it, then essentially you have a bunch of provisions that are dead letters. So I think that this bill in its entirety should be withdrawn. And I think we should reconsider the entire exercise. Thank you.
Thank you so much for this, Meghna. And Mr. Peters, would you like to share a few words or your thoughts? And sorry to put you on a spot. No, I guess not. Is there anyone who has any questions? Anupam, there was a question for you. Would you like to respond to it? I had sent it to you over chat.
Yes, sure. So Ujjwal is saying that considering that there are competition concerns impacting mainly the business side of platforms, and recognizing that e-commerce platforms choose to neglect the recommendations of self-regulation, which was proposed in the CCI e-commerce market study, can we have, instead of hard law like this DCA, a soft law approach, which is guidelines and exercising, while CCI is exercising its mandate to prevent anti-competitive practices? Yes, it's a no-brainer to have soft laws, to have more of, in fact, a deeper market study based on which soft laws and guidelines, you can have white papers, you can have green papers, to explain and to understand, to involve the stakeholders, to understand how their product design and the user interface is making their business model, or how they are monetizing it with that, instead of any anti-competitive activity. Once they are more in tune with how the ecosystem works, how there are different value creating platforms as opposed to bundling, and how there are ecosystems which cannot be matched with just B2C, B2C and B2B, B2C transactional platforms. So after understanding all these nuances, if there are guidelines, or if there are even notices for market definition, how to define, a certain, like I'm saying, these different markets, or at least first principles based, behavior, how to have, control bias. So anti-bias principles, portability principles. So if you give principles, then it's easier for the companies to comply, and it also gives a framework for them to work on, and then it becomes like a sandbox where all stakeholders are working towards it, and you already have a law which you can enforce. You have penalty guidelines, you have settlements and commitments, so you have enough power. There's no dearth of power over here, and it can work.
Sorry, I will have to stop you here. I think since we've run over time, Samir and others would like to leave. Samir, thank you so much for being here. Even Vishy, I know you have to leave, but in case you have some last 1 minute, one-liner you want to share, please do so before you exit.
Well, thank you so much for having me here. Enjoy the conversation. Some interesting reading material to pick up on. Thanks, Vishy. And yeah, I think I'm hoping that Meghna's right and they can just repeal the whole thing and start over, because what I managed to actually read a little more of it while I was sitting here, and I don't think I'll sleep well tonight.
Amrita, you are asking me to speak. I was muted. That's why I don't have much to say, but intuitively, I feel that it is better not to have this low ex-ante regulation at the moment. We have to wait. Lot more of work needs to be done. I think impact on innovation, digital market development, digital literacy, everywhere, I feel that the ex-ante regulation will do more harm to the Indian economy in the medium to the long term. So I am convinced. See, the thing is that a lot of discussions have, I think even here, the convergence of view is in that direction. Because we had experimented with, it is reminiscent of the MRTP days. Ex-ante regulation, it has got an inherent issue, which you are unleashing something, and then it will be sort of rewinding lot of new issues adversely affecting the sector and the people, especially the consumers, general consumers. I think I stop here. I'm not going to take more time. Yeah.
Thank you so much for your views. You've been seeing this and you've been part of it, so you understand from the other side of the fence as well as looking at it now. Thank you so much, sir. Sorry to have caught you off guard, but I thought
it's okay. It's okay.
Valuable. So yes, Vishy, last one-liner or any word you would like to add?
Nothing. As I said, you have to look after for small businesses. They are the consumers of platforms as well. So be careful in what you regulate. That's all I will stop at. Thank you. I need to get going. So thank you very much.
Thank you so much, everyone, and request others to make, your comments, at least requesting for extension. If others are making some points, we will share. But Navneet, Vivan, Anupam, Meghna, and Saksham, your last one-line thoughts. And anyone can go first.
Navneet, sir, please.
Go ahead.
Everyone's very polite. I'll just say contestability.
But yeah, I'll go. First mover advantage, maybe, I don't know. But no, of course, I think my last submission is that this is not a positive sum game, right? This is not a zero-sum game. There are going to be trade-offs. Whether you're a policy analyst, whether you're a lawyer or a business, a small business, a large business, whether you're a government regulator, there are going to be trade-offs. There are certain calls for going back to the drawing board and starting over. There are also calls for, going steadfast on this and coming out with something ASAP. Whatever approach you may decide, ex ante, no ex ante, regulation, principle, etc., trade-offs are going to be there. So rather than going on either side of the spectrum or being bipolar, for the lack of a better word on this, assess the trade-offs, then decide what is it that you want, and then go ahead with it. And with that, I will end.
Thank you so much. Who wants
I
to go?
think the businesses need to be a little more proactive if they want to really debunk the myths of ex ante, or to safeguard their business models from not being restructured, etc. So yes, like Vivan said, we've been very polite, but it's time to really take the bull by the horn, or the elephant.
Yeah, thanks, Anupam.
Yeah, just to respond to whoever said that businesses are also on the receiving end of anti-competitive conduct, or are also the consumer welfare standard should apply to them. I agree. And all research points to the fact that a majority of businesses will be worse off if this law comes into force. So I don't think that any law that considers the narrow paradigm of seeing businesses and larger platforms as competitors, and basically only existing to support the competitors of platforms and their narrow business models, should not have a place in our larger kind of legislative arena. That's all I'll say.
So Navneet, you are the showstopper. So the last word goes to you.
I think in terms of approach, I recommend dispassion. We need, right now the debate is very passionate. We need a lot more dispassion so that we are able to ask right questions. We are able to look at specific segments and the potential impacts, so that, before we really make it into a law, if at all we make ever, we have solid clarity in terms of impact on startups and SMEs, that particular segment, because that is where the next set of growth will come in. So that's very critical. And also, of course, I don't want to miss the consumer impact, because ultimately the greatest beneficiary of healthy competition is consumer. So therefore, that also cannot be lost sight of. Thank you very much. Great initiative.
Thank you so much. And thank you everyone for being here and participating for nearly 2.5 hours. I think some of the key takeaways is we need more time to kind of deliberate, find out, identify as in who is it we want to regulate, what is it we want to regulate, and try to differentiate understand the different parts of businesses, their impacts, their interlinkages, speak to more, perhaps initially when the committee was deliberating, they took a very small section of people and spoke. We can work on our past mistakes and make it more widespread, have more consultation on this, and not rush to form a regulation, because the intent should be to try to address the present gaps, not that we have made a regulation, or try to create another beast who we will take a lot of time to kind of, I would say, rein. And as Saksham mentioned, there would be trade-offs, but to know how to trade it, it is important for everyone to come to the same page as to how technology works, how businesses work, how bigger and smaller businesses, the relationships are, what are the, obviously take care of the harms, but also not try to over-regulate, or else the aspirations which India has, would be challenged if we want to achieve those goals. So I think with that, we would end this round of conference and discussion. In case we have an extension, we may want to deliberate on different aspects of it, but let's see how it goes. We'll try to come up with a report, and we'll first share it with our experts, get their views on it, and then hopefully share it with everyone. So thank you so much, everyone, for being here.
Thank you very much for having me.
Thank you so much.
Bye-bye.